Hello everyone, good morning. Today is the day 2 of the conference. We're starting with a little bit of a warm-up. So it's not a typical morning of another day during the conference, it's a workshop. But before we get into the details, a couple of words what's going to happen today. So as you know, this is a conference about the flow of information, and we're looking at the flow of information from different perspectives. You heard a lot about the DMA, DSA, and other stuff yesterday. And today we're getting into more niche topics. That's why we're starting off with a workshop prepared by Summer Institute in Computational Social Science, which is a special location of a worldwide project on computational methods in social sciences. That's why you're going to experience a couple of minutes from Mickiewicz and the 6th team that's going to be introduced just in a second. And after that, we're going to start the real meritoric panel of today. So we're going to delve into topics of neurotechnology, and we're going to do a special introduction for that as well. So with this very short introduction, let me introduce Paulina and Mikołaj, who are the members of the 6th AMU Law, so the Summer Institute, Summer School on Computational Methods. Paulina would introduce what they do, and Mikołaj will start in a second with what he prepared for us, showing a little bit of what 6 about. Thank you and have a good day.
I'm smaller. Yeah. Hi everyone. I'm Paulina. I'm from 6th AMU Law, and here with us is today Mickiewicz. He is a PhD student in empirical jurisprudence at the University of Warsaw, and he was our first edition participant. And he will show us how to use the computational methods in his research, how he's doing that. Yeah, so I think we can start with that, because we have like a little bit of delay.
Okay.
It's working, yeah.
That's great. Hi everyone, my name is Mikołaj, as it has been mentioned several times. I have been a 6th participant 3 years ago. And I will be talking briefly about my PhD project, but more from a methodological perspective, how to approach empirical problems in legal research, and showing that on example of my thesis, which is studying legislative inflation. Who I am, it has been mentioned, I'm from Warsaw, I'm not from Poznań, but I have cordial relationships with everyone here, hopefully, and I am preparing a PhD in empirical jurisprudence, which is like this branch of theory of law, which focuses heavily on empirical methodology and implementing that in research. What I will be talking about is a little bit of showcase how to use quantitative methods to examine specific legal issues. Maybe that's not one-to-one connected to DSA or other digital markets and such stuff, type of problems, but it can be implemented to study them. I will be showing how to approach a comprehensive project which is aimed at investigating a given phenomenon, which in my case is legislative inflation, how to approach, what techniques to use to analyze large collections of legal data. In my case, that's legislative data, but that it doesn't have to be legislative data per se. What pitfalls and problems you may encounter while doing that, and maybe some methods and intuitions to use while conducting such a project. Where the first question is, why study law empirically at all? Don't we have well documented and tested doctrinal method? Well, yes, but actually no, because doctrinal method and traditional dogmatics are perfect for one set of problems, but they are not well suited for another types of them. And I guess that really depends on what questions are you going to answer or what problem are you going to solve. And it is being said in jurisprudence lately that the so-called maybe skepticism among legal scholars in implementing empirical research is holding jurisprudence back a bit, maybe in comparison with sociology and other social sciences which implemented those methods. Legal science is a little bit slower moving, but it's happening. So the crisis of traditional dogmatics means just that there are questions that we are unable to answer using those methods, and maybe implementing other would help. So this is empirical approach is just one of the methods of diagnosing problems inside of the legal system, of outside of it, connected to the legal system in general. And computational tools offer us methods and instruments to approach legal issues from a different perspective. Computational, quantitative, whatever you name it, we can move past the limitations of manual analysis, of doctrinal analysis, and measure what would be impossible to measure or analyze using those methods. For example, in my research, I am analyzing hundreds of thousands of legal acts published in official journals. That would be impossible if I was to read them. Right? This would be absurd. So what is legislative inflation? Just a brief introduction to the problem at hand. It's a problem which is kind of popular, I guess, in popular science and in legal research as well, because from ancient times, people have been complaining about legal excess, right? Tacitus has said that the more laws are there in a state, the more sick the state is. And it continues through the ages up until now. We can define legislative inflation as legal excess or maybe legal instability. Every factor that contributes to the fact that legal addressee is burdened with information in a scale that's assessed as being excessive. Usually legislative inflation is being connected with the degradation of the linguistic and normative quality of law. So the more laws there are, usually it is being said that maybe the quality is decreasing, maybe the system is being unnecessarily complexed, and so on. And usually it is being approached, this problem, legislative inflation, from the perspective of causes and effects. So we are thinking about what contributes to the fact that we are dealing with such an excessive activity in legislation, and what do we get from that. Usually when it comes to the effects, we will focus on bad ones, but there is some literature that says that there are also good effects. But not only that, but it's prevalent in most modern countries. In organizations, there is little evidence that countries such as Japan have conquered it somehow. But usually, it's for now it's prevalent. But using traditional doctrinal method, we would be able just to analyze the causes, the effects, using like for example, dogmatics and conceptual analysis, but we are unable to measure what's happening actually in the legal system. So we are I am aiming, but I'm just a part of bigger wave that's happening. We are aiming to make it more quantitative, make it more computated, and aim to measure it in a way that's reliable for other people to reference. Well, if we are approaching an empirical problem, we are trying to start the project, we need to first formulate some questions, just as when it comes to the doctrinal method, we notice some phenomenon that requires some kind of measurement. In this case, it is legislative inflation. Maybe we are noticing that there is perhaps too much regulations. Maybe in the European Union, we think, well, how come the European Union is issuing so many regulations, so many directives, and how does that impact the legal system of the European Union and legal systems of countries that are members of that? Maybe there is too much regulation, but after we formulate this question, we need to contemplate how to transform this question into a measurable one, because just limiting ourselves to spotting that there is an excess in legislative activity doesn't provide us with a reliable point of reference further. So we need to operationalize the notion. Whatever notion. In this case, this is legislative inflation or maybe legal instability or legal complexity, but in another case, some notion needs to be operationalized for it to be measurable and then to be replicable after that in other studies. So if we need to operationalize a variable, we need to get a variable that can be expressed in some kind of data. In my case, in case of legislative inflation, this is volume of legislation, one might say, maybe a number of regulations per year, maybe accumulated number of regulations, maybe number of amendments per year. These are some examples that one may come up with when selecting such a variable. The most important thing is that it needs to be expressible in data. So we need to have some point of reference which can be listed, which can be documented and then referenced. Yes, as I have mentioned, complexity of law, maybe that's a variable that can be expressed in data. It depends how we define it further. Maybe legal instability, when measured using the frequency or number of amendments, maybe that's something that can be expressed in data. Usually it could be quite good approach. Then the most tedious part, after we formulated the research question and got ourselves some perspective how to conduct research further, then we need to actually get the data. In my case, the data is legislative data, as I have mentioned. In my PhD, I am working just on Polish legal data, but that doesn't have to be the case. We need to get this data from somewhere. Well, where to get the data, it depends. Because it depends on the research question, it depends on the data that we actually want to have. When you conduct, for example, qualitative analysis or some opinion-based research, you may have just to conduct some surveys with, for example, judges, members of parliament, or whatever institution you are working with. Maybe you need to get judicial data, then you would need to contact maybe some institution, contact some courts, or get the data from the internet, or legislative data, as in this case, we would need to contact maybe Chancellery of Polish Parliament, or maybe some other institution, or get the data on our own. When it comes to legislative data in Poland, we have this ISAP system, which is a system for publishing the normative acts online, and it has some point of contact, which is ELI API, which is a point on the web which can be contacted via programming language and then used to obtain some information. When it comes to EU, there is EU-Lex, which is the website with all European Union regulations and judicial decisions, and there are some programming packages that provide us with easier access to this data. well, obviously it's easier when you are working with the data that is collectible in an automatic way. In that case, it means that when data is published online in some structured way, like, for example, in the European Union and its regulations, you could automate that and spare yourself some time for collecting the data, which is obviously an advantage when you are working with questionnaires and so on. It's not so easily done, but when you're working with just text data, you may have a chance to automate that and make the whole process easier. As I have mentioned, usually it's also very convenient to contact the institutions directly. Sometimes, and from my experience, it happens that the institutions are so happy that someone is actually wanting to research the stuff that they are doing, that they are the employees of such institution are very happy to help. I have a very positive experience with contacting Polish Parliament Chancellery. They have been most helpful and provided me with stuff that isn't accessible online, because they put some stuff online and some stuff is just their working material. So that can be convenient way to approach the problem. Yes, and here you can see the Polish ISAP system, which is like Dziennik Ustaw, the Journal of Laws. When you open some act, in this case it's Journal of Laws from this year, position 761, which are some amendments to international conventions of I don't know what. And if you go on such page, you can open a PDF file with a text of that normative act, regardless whether it's, for example, such amendments or a statute or a directive or whatever. But if you are to analyze thousands of acts, this could be quite tedious to do, to get on every other page and download PDFs, and still we don't even know yet what to do with those PDFs. So that's not automated at all. But as I have mentioned, we have ERI API, which is like this European identifier of legislation, which provides the people who are interested in that with structured way of publishing data. So it's in Polish. I'm sorry, but this link at the bottom of the right image, it says HTTPS and so on, EIRI/journal/year/position and so on. So these curly brackets indicate that you can change the content in an automated way. So year, for example, we can swap 2025 with 2024, and we would get a relevant given position for a previous year and so on. So we can already see that it's possible to obtain some data in a way that's maybe not requiring manual downloading. And this is a result of obtaining such metadata for a random act in 2020, position 80. So we can see that here, well, it's Polish, in Polish as well, we can see that there are many fields with some values. So for example, identifier 2020/80, announcement date, position, date of promulgation, so where it has been published, status of a given act. In here it says wygaśnięcie aktu, which in Polish means that such an act is no longer valid. Text HTML and text PDF all both equal to true, which means that we will be able to obtain a text of a given act both in HTML and PDF. A title, a type, obwieszczenie, which means announcement, so it's not a statute. And for example, keywords. Like in here we have rolnicy, rolnictwo, so agriculture, rozwój obszarów wiejskich, development of rural areas, and pomoc finansowa, which means financial help. And keywords names, which are the institutions or some funds that are connected with this act, which is Program Rozwoju Obszarów Wiejskich, which means like a program for development of these rural areas, and so on. So this is a little bit more promising than before, than what we have seen here on the left, because what we have seen here on the left is quite easy to read, but not as easy to download and structure, for example, even in most easy case in Excel file. This, what we are seeing here, is easier to transform to such tabular data, and also provides us with information that we haven't seen then. So we didn't see keywords at all, and now we have some classification that we can use. Maybe this act is connected to agriculture, and if we connect that act to other acts that are connected to agriculture, then we can derive some information later. But for now, we have this metadata, not only text. We can see that text is available, but we have also metadata that describe this normative act in some technical way. So let's say we get this text, we get this metadata, we download that, we download, for example, every act in 2020, and then we have another problem, because we have the data in source format, for example, PDF. PDF, we all know that. XML, which is like also structured way of processing information. HTML, which would be I guess which would have many these pointy brackets with some commands and H1, H2, and so on, and it would not be easy to read by person. And JSON is a format of storing data which involves some curly brackets and so on. This file is stored in JSON, but this is just a view that my browser provides for displaying JSON files. But it's just this key and value per organized way of storing data. And that's not easily read by humans. We need to decide whether we are wanting to read this information for now, or we are wanting to use it further to some research. Maybe PDF is not... PDF, for example, it's very easy to read. It's designed to be read easily, but it's not that feasible to process when it comes to extracting texts or extracting information directly from the file. So then, obviously, we need to transform this file or transform this data that we have from a format that is stored in to a format that can be analyzed by us further. Maybe it's an Excel file. Maybe that's all we need, but we still need to transform it somehow. Maybe we need to first, we need to implement optical character recognition, which is, as some of you may know, a method of identifying letters, characters from image. For example, maybe it's not the case with European Union law, but in Polish law, these easily read files are maybe from 2011, 2012, and before one might need to implement optical character recognition to derive text, extract text from a scanned image of printed journal of laws, which has been used for most of the 20th century. Then we need to probably parse the documents into a specific structure, because after we extract text from PDF, for example, the text is obviously unstructured. It's just a string, just a collection of letters and numbers. If we want to analyze, for example, provisions and so on, then we would need to segmentize this text into a structure. And obviously, metadata, as I have shown, this is quite an important task to obtain that, since it provides us with more information about what's actually happening with the file. Maybe, for example, when it comes to judicial decisions, the metadata would contain a judge that's issuing such a decision, or a procedure or legal basis, and so on. So this is Polish Journal of Laws, Dziennik Ustaw Rzeczypospolitej Polskiej, and this is like the directive of Minister for Climate and Environment about some wood, or I don't know, position 746 in this year, and this is PDF format, right? So this is what we are downloading, and after optimal OCR, we get something like this. This is not the same act, but it shows the method. We get some TXT file, just plain text with information about just derived from the PDF file. So we have everything that's happening in the PDF file. Dziennik Ustaw. We have like the place and date, position, every provision, obviously, but also indentations, also superscript like references and so on. So this is something that probably will need to be handled later when it comes to like cleaning the text in order to proceed with analysis further. So as I have said, then segmentation needs to happen and maybe classification of provisions. In my case, I was wondering what should be the unit of analysis. Maybe a word, maybe a sentence, or maybe a provision. When it comes to provisions, I should refer to different classes of provisions in legislative technique. In Poland, we have like this annex to decree of Prime Minister with rules of legislative technique. When it comes to European Union, these types of provisions may differ somehow. Maybe the classification is different, would be different when it comes to any other jurisdiction. One would need to refer to these jurisdictions' set of rules of legislative technique. For example, in Poland we have like this typology of provisions which divides them into substantive ones and not substantive ones, which are divided into like amendments, final provisions, introductory provisions, and so on. When it comes to this classification, we may obviously do it manually because this is harder a bit to automate, but we may as well try to automate these classifications of classification of provisions using, for example, language rules. For example, we observe that in some kind of final provisions we always see some structured way of using words in a sentence. For example, provision this and that comes into force on such a date. So comes into force is a language form that happens always in such provisions and doesn't happen usually in any other provisions. So we can use that form to classify, to identify final provisions and provisions that are not substantive. Then we should use some kind of also natural language processing methods, which would include tokenization, which is dividing the text, identifying each and every token, which is, for example, a word, and lemmatization, which is transforming a word into its basic form. I have said transforming, so the word transforming, lemmatized would be changed to transform because that's the basic form. That is that B. So lemmatization just reduces a word into its most basic form for further analysis to be possible. For example, to part of speech recognition and so on. And we can obviously use some self-imposed rules because this is kind of research that combines both empirical tools and also like rule-based techniques, which would include our own knowledge, domain knowledge, expert knowledge derived from literature and so on. So this is, for example, a picture that shows how regular expressions work. There is a website, regex 101, on which you can test how a given string is identifiable. For example, here we can see that some set of emails or strings that are similar to emails are tested, whether they can be identified using some regex techniques, which include, for example, A to Z, so spot every letter from A to Z. If it happens, a symbol plus means that happens once or more. Then maybe have at symbol, and then some other string, dot, and some other string. So john@company.net is being indicated as satisfying all of these criteria, and example.com is not satisfying those criteria because it doesn't have at symbol inside of that. And this is an example of of a text of a this is a directive of my Minister for Finances in Poland, which is already segmented by me, but not manually, but using some kind of script, segmented into beginning, paragraphs, because I was focusing on paragraphs, and then the end. And inside paragraphs, I implemented ID, which indicates which paragraph of which number that is, text of such paragraphs, and classification. Here, every paragraph is classified as general provisions, but this might differ when some other script would be implemented, and every text is being classified into every provision. So, for example, paragraph number 1, directive handles with some payment and so on, and then paragraph number 2, and so on and so on. And what's tricky in such a task is that, for example, in my case, I needed to differ between provisions that are amending some other provisions and provisions that aren't. So if I wanted to just focus on classifying the provisions that are parts of this directive, I wouldn't want provisions that are amendments to be classified on their own. I would want them to be part of the provisions that they are part of in this case. But that depends every time on the task at hand, and you would need to think this through on your own when you would handle your own research. And then finally, the icing of the cake, on the cake, so measurement and quantitative analysis. It is being said that in data science, usually data cleaning, processing, obtaining the data takes, well, and it's optimistic, look, 80% of the time. So the most tedious work, the most uninteresting part of work takes 80% of the time. So actual measurements and quantitative analysis is really icing on the cake indeed, because it comes at the end. So I needed to try to answer the question, for example, how can the volume of law be measured? Maybe what is the difference between the number of regulations and the number of changes? Maybe how to measure one and how to measure the other one. Stock and flow indicators, that is referring to a theory of legal stock and legal flow, which was proposed by Joński and Rogowski in 2022. In their paper, stock of law is like accumulated number of regulations in a given jurisdiction, and legal flow or stream of law, but in this case legal flow means number of changes. So I needed to differentiate between those two in order to be precise with my calculations. I wanted also to take into account the repeals, the amendments, entry into force, so everything that happens actually with the legal and normative acts that are being implemented in the Polish legal system, in my case. So let me show you some examples, which are most spectacular ones. Sorry for Polish title. So, for example, here we can see how many % of acts have been changing other acts from 1920. So, from the beginning of Second Polish Republic. In orange color, we can see statutes. In red color, we can see directives. So we can see that in Second Polish Republic and at the beginning of Polish People's Republic, the percentage was quite stable. around 20-30%, and then from the 50s there is a big difference because statutes started to amend more and more statutes than before. It peaked to 60%, and then after some years in the Third Polish Republic, we are living right now, we have it stabilized at around 80-90%. So 9 out of 10 Polish statutes amend at least one other statute. This can be incidental amendment, so just changing of just one provision in other act, but this can also mean very structural changes and implementation of some substantive reform. And when it comes to directives, they also peaked, but not as high. They stabilized at around 40-50%. But when you take into account, and this is interesting, why one needs to take into account multiple perspectives of looking at the same problem, when you take into account how many acts are being changed by an act that's changing something. So if an act is changing another act, how many other acts are being changed on average? We can see that when it comes to directives, they usually stabilize at 1. So if they amend, they probably just change the previous version of something like this. But when it comes to statutes, they are peaking in the last 10-15 years from around 4 on average to around 6-7. So 75% increase. That's quite a substantive increase, and that would not be observable if we were to limit ourselves just to count the percentage of acts that are changing in other acts. So despite the fact that usually looking at the problem from different perspectives doesn't provide us with new knowledge when it comes to such studies, there are instances when it does, and this is an example of such an instance. Another example from research, this is Polish legal stock since 2012 in words, or I should say in millions of words. And what is Polish legal stock? Let me remind you that legal stock is a cumulative number of words in force. But usually when it comes to legislative inflation in literature, researchers tend to limit themselves just to count normative acts or words in normative acts that are being published in official journals. Well, if we were to count those words, we would obtain a number equal to 180 million words. But if we were to limit ourselves just to statute and executive acts, so the acts that actually construct some obligations and rights, the number would drop from 180 million to 75 million. So this difference derives probably from the fact that since 2012 we have regulation that obligates the Marshal of Sejm to publish announcements with amended text of a statute and so on, and these superficially multiplicates the number of words published in Journal of Laws, but not accounting for such a factor would be grossly misleading. And if we were to limit ourselves inside those statutes and executive acts only to provisions, so we are discarding titles, appendices, and so on, the number would drop from 75 million just to 31 million, so another 50% more or less decrease. And if we were to account the provisions that have gotten out of force, so that were being repealed, the number would drop from 31 million to just 25.5 million. So only 25.5 million words since 2012 have been valid, implemented in statutes and executive acts in their provisions. But if we were to count all the words that have been published, we would get a number that would be around 7 times larger. So that would be a mistake. And this mistake usually happens when it comes to research that is being done in a more shallow manner. So just counting a number of acts that are being published, or just counting number of pages, and so on. And depending on the problem that you are handling, when you are handling, for example, judicial decisions in the EU, these kind of pitfalls might differ, obviously, but usually they are there. So you need to be careful when it comes to trying to spot such pitfalls. And the last but not least, mean provision length by category and type. So we can see like bar chart with mean provision length in every branch of law as follows: administrative, penal, labor, constitutional, civil, social, insurance, tax and finance, and trade law. And those two bars signify two types of acts. The blue one is executive act and the orange one is a statute. So in almost every case, apart from constitutional law, in almost every case, mean length of a provision is greater in statutes than in executive acts. Why is that happening? That's a question worth analyzing, but beyond the scope of such a graph. But when you take into account overall mean length of a provision, we can see that it didn't change that much, at least in the last 10 years. And it's a great, in my opinion, it's a good example for polemics with the theses that are being published in literature, that the legislative inflation means that provisions are getting longer and longer. Where from this graph we can see that they are not. They are longer on average in statutes than in executive acts, but they are not getting longer in general. So that can be discarded. Well, to conclude, how can this approach be transferred to other countries of areas of law? Well, when it comes to other countries, it's quite easy. You would just need to adjust the method for it to be applicable to other jurisdictions, to take into account the differences in legislative techniques, in normative acts that are being implemented in such a jurisdiction, or other areas of law, as I have mentioned. It all depends on the question that you are trying to solve. This question will determine the data sources that you are going to use, and then the methods of analysis that you are going to implement. If the method fails, because it fails a lot, it's like a Sisyphus problem. You need to stand up again and try to find a workaround. If you fail, in my case, when I fail, you just need to refer to external sources of knowledge, because the main, in my experience, the main lesson that I have taken from dealing with empirical methods is that I know virtually nothing. And each time I need to refer to some specific knowledge that is being, for example, in statistics, stored in statistical literature, or machine learning, or any other information technology, linguistics, specifically computational linguistics, and so on. If I want to be more cautious, I would want to document the code even for myself, because when it comes to empirical projects, they soon tend to grow in size and quite quickly become ungovernable, and use version control, which is a programming method of accounting for changes in the code. What to work in, because that's another question. How to do that? How to construct code that would transform such, for example, in my case, such JSONs and such metadata into a data that can be analyzed in a quantitative manner. Well, there's no workaround. You would probably need to use some programming language, for example, Python, which is the most popular, and there are most resources for Python. R, which is designed specifically for statistical analysis, and there are also others like C, which is more general use programming language, MATLAB or SQL, which is a structured query language. You would probably need to use, when it comes to a software, some integrated development environment, which is called IDE, like PyCharm or VS Code. Maybe Jupyter notebooks, which are designed to work with Python code. And for version control, there is a neat environment called Git, and GitHub, a page designed just for this purpose. Right now, we are dealing with AI revolution and so on. So there is no surprise that it affects also, maybe mainly, software development and as well empirical methods and empirical research. There also obviously is ChatGPT that you can use, for example, to advise what methods to use, what tools to use, what instruments to analyze, what kind of tests you should utilize to maybe derive some statistical significance. But there are also structured ways called agent systems, structured ways of software development that are used for just for programming and that are kind of proficient in not only constructing code and providing you with code necessary to execute some script, but also with project development and controlling the overall holistic picture. For example, Windsurf or Cursor, and those are great tools. Where to seek help, I will show that in a minute. For example, in Stack Overflow, there is a great site with questions and answers. And if you have questions regarding empirical methods or implementing some programming tool, there is a high chance that someone already had that question as well and asked it publicly, and then it has been answered. And so maybe after some tweaks, you could use that answer for your own purposes. Where to learn as well, there are many resources on the web that are utilizable when it comes to empirical methods. I would say way more than when it comes to doctrinal methods, because they are way more universal. So for example, this is Cursor. It's not my print screen, but I just downloaded it. And you can see that on the left there is code. I don't know in what language, but someone is programming something. And on the right there is like this chat pane in which a user is asking questions and commanding the LLM basically behind the scenes to do something. So can you make it easier to switch certificates in the transport? Listeners, I don't know what that is, but yes, the model answers that it will help to modify it and proposes some changes in code that can be just accepted and that doesn't require that much expert knowledge. But despite this, I would advise if you are to try to implement some empirical methods, it would be good to at least try to know the basics, try to know what's going on for you to be able to correct the model when it makes a mistake, for example. And this is Stack Overflow, which we can see that there are 22 million questions. I don't know from where this screenshot is, but some example questions and so on. Obviously, ChatGPT. This is DataCamp, which is a website that I have used at the beginning of my empirical journey for learning, just learning the programming in Python or R. Udemy also provides you with several courses in not only in programming but also with data analysis that doesn't require programming, because there are tools, there are problems that don't require scripting or in any kind. And to sum up, well, I know that I know nothing. That is the main takeaway, because when you try to leave the doctrinal world of legal analysis, you open the door to the whole new world that is out there, and you won't be provided with any knowledge that is complete or comprehensive. You would just be equipped with tools that you can use to apprehend such problems. You would search a little in the unknown, to be poetic. So it requires both domain knowledge, and I assume that you all possess such knowledge, and analytical skills. If law and legal academia is being traditionally perceived as a safe space from maths and so on, it will be no longer such a safe space, in my opinion. But the main advantage is that you can just craft your own path to what you are trying to measure, to what you are trying to analyze, and it gives a great deal of independence in researching a problem, to be able to rely just on your own competence and just your own skills to analyze some problem. And just important thing to remember, it's not that it's some kind of revolution that is going to substitute doctrinal method or traditional dogmatics. It aims to reinforce it. It aims to provide it with tools that are useful in many ways, and make the researchers able to conduct a deeper analysis of legal reality. Also, it is quite easily transferable knowledge between countries. When it comes to empirical methods, those do not differ like legal systems do, and approaching some legal problems from even national legal problems from empirical perspective makes it possible to compare such analyses with other countries. For example, from my experience, I conducted some analysis from Polish legal language for my master's thesis, and in the last months I have been cooperating with people from Italy on conducting similar experiments on Italian law, and the results have been similar, that regardless of legal system, some linguistic features of legal language remain the same, and comparisons between legal branches are quite similar. So these are takeaways that are quite internationally recognizable and easy to exchange. That would be all. Thank you very much for your patience and for your attention. I am giving the microphone to you.
Thank you very much, Miko. I think we're running out of time, so you have now the coffee break to ask questions to Mikołaj Ryszkiewicz, but I have one question, and please answer just with one sentence. If I'm not an IT guy, I cannot program, I don't know what the SQL API, whatever is it relatively easy for me to start doing this kind of stuff?
It is possible. It is relatively easy. It would be required for you to be a little bit more patient with yourself and with the experiment.
So that's the hardest part. It's not the programming, it's not software, it's not code.
Yes, it's just, as I have mentioned, the most part is just the tedious work. So if you are dedicated and committed enough, it's possible, I guess.
Thank you very much. It's a great outcome, great conclusion. And right now we're starting our coffee break. And please mind the fact that we changed the agenda for day 2 slightly. So 10:15, we're gathering back here, and we're going to start with an introduction to neurotech. So please observe our agenda online. There's a slight change in the times. We're going to finish at 12:45 instead of 1. But altogether, we're still staying in this area, so all the other events going to be hosted here. So right now, please enjoy your coffee break.
Good morning, everybody. This is my pleasure to welcome you at the second day of our Digital Single Market and the Free Flow of Information conference. The day 2 just starts just now, and the day 2 on neurodata and neurorights is the proof of how much we are interested in data flows and information flows, not only on the market, but also from the more personal perspective, which will be elucidated today. So the topic of neurodata and neurorights brings up many questions concerning not only the data that we see on the table potentially, but also the rights. So we can discuss the fundamental rights, the right to privacy, personal data protection rights, we can discuss intellectual property, and we can discuss the scope of the right or freedom of research. So we are going to have an exciting day up until lunch, and it is my pleasure to welcome Wojciech, who will moderate this first session of the second day. Thank you very much.
So yesterday evening we talked with Hannah and Marcin about the introduction to neurotech, and Hannah Thornton is a lawyer and Marcin is not a lawyer, and he said that he was preparing for a 15-20 minutes talk, and it took him hours to actually prepare something that he's very familiar with. But he had this understanding that we as lawyers and legal scholars were stepping into terra incognita. So that we know nothing, and this is what we share with the introduction by Mickiewicz during the workshop. We know nothing, but we want to know something and understand better. So with this introduction, we're having two great speakers, Hannah Thornton, who is a lawyer, who is one of the first people that dealt with human brain and machine interfaces. So she knows the legal landscape, and she had to understand technology at some point in order to tell us what's the law regarding the machines that connect to brain, that interfere with one's body. But then we thought, it's our sin as legal scholars that we stay within our bubble. So then we thought, let's go to Marcin Naranowicz, who is a PhD. He's not a lawyer at all, but he's the guy that uses all these kinds of devices to actually use the technology that we're talking about. And Hannah and Marcin will do a great duo today, because they're going to show us both the very stuff we're talking about, so that perhaps later you can try on and see if you're doing great or not. But then we'll try to understand what's the fuss about, and try to initiate a legal debate around it, and see what's the neuroscience, what neuroscience tell us about the neurotech, and why we as legal scholars should focus on it right now. So we have Hannah Thornton, who is a PhD. She's now a practicing lawyer, and we have Marcin Naranowicz, who is a researcher. He's from the Faculty of English, so you may say, well, it's very far from law, but actually it's not that far. So I leave the floor to both of you, and I really invite you to ask them questions and really seek out what's there in neurotech, and I keep fingers crossed for letting us leave the bubble that we are in. All the best.
Okay, so welcome everybody, and thank you so much for your kind introduction, and also for inviting me and Hannah here. And so today, together with Hannah, we'll take you to a short journey through a fascinating world of neurotechnology, a field where neuroscience meets innovation. And I have a great pleasure to actually open this panel as a scientist, as a neuroscientist, as a psycholinguist, and I hope that we'll learn something from one another today. Okay, so the first part of this talk will actually aim to establish the scientific foundation, right, for subsequent discussions over legal and ethical aspects of using neurotechnology. And here I want to offer a small disclaimer. So I will be mentioning some products of specific brands in my presentation, but this is solely for demonstration purposes, and I definitely do not gain any financial benefit from their mention. Okay, So this is a short outline of what I will be talking about today. So I will first try to define the term neurotechnology so that we're all on the same page. Then we will delve into electroencephalography, so one of the methods used to study the brain. Then we will zoom in on one of the techniques that we use to study the brain, so event-related potentials, and I will provide you with one example of my research published this year. And then we'll smoothly move on to wearable neurotechnologies, something that many people actually here are interested in. And finally, I will actually finish at the same time opening Hannah's presentation, trying to, in a way, pose a question whether neurodata can actually be considered biometric identifiers. Okay. So as promised, let's start with a short definition. So broadly speaking, we can say that neurotechnology are tools and methods that are used to study and monitor, then stimulate, but also interface and train the brain and the nervous system for different purposes, be it medical, scientific, or commercial ones. So here you can find a short list. It's not an exhaustive list, but a short list of neurotechnology that is non-invasive, and it's used for those particular purposes. And maybe I'll mention some of them just to show you the scope of what neurotechnology does, right? So we have, for instance, EEG, so electroencephalography, which measures the electrical activity of the brain. Then we have fMRI, so functional magnetic resonance imaging, that actually tracks hemodynamic changes, right? So the inflow of oxygen-rich blood in the brain. We also have transcranial magnetic stimulation, right, which is a device, a technology that sends small magnetic fields to the brain to stimulate it, and is frequently used in psychotherapy, in depression therapy in particular, but also to study neurocognitive processes. We also have neurofeedback, again, famously used in therapy for ADHD, for instance, which is a kind of equipment that helps people self-regulate their own mental state. And then they receive neurofeedback from the machine, and they try to, as if, adjust their thinking patterns so as to focus better and regulate emotions more effectively. So, as promised, we will focus a bit more about electroencephalography, because this is the kind of methodology that was embraced by neurotechnology to a large extent, and this is what I do on a daily basis in our laboratory. So EEG is a non-invasive method that records the continuous brain activity through the placement of electrodes on the scalp. You can see actually those electrodes here. This is what we have in our laboratory. So what it does, it captures voltage fluctuations that are generated by postsynaptic potentials. So this is the moment when neurotransmitters are released and when two neurons communicate. So EEG is actually famous for its excellent temporal resolution, at the same time poor spatial resolution. What it means that basically we can track all the neural changes with precision of 1 millisecond, and we can measure the strength of the brain response. At the same time, it's not very good at detecting where in the brain specific brain activity was generated. So this is what fMRI is for. So its primary use was in medical research, right? So it's a great tool for diagnosis of epilepsy and sleep disorders, and also a tool that helps us confirm brain death. And medical staff typically use 21 electrode systems. Then later, it was harnessed by researchers, by neuroscientists, and actually it's used to study neurocognitive mechanisms, right, including focus, attention, memory, language, decision-making, you name it, right? So all the possible neurocognitive mechanisms that we can study. What's quite critical here is that we use many more electrodes because we need high precision. So typically 64 or 128 electrodes are used for research purposes. So the preparation time is the preparation is a bit time consuming here. So how we analyze EEG data. So basically there are two tools or two methods that are quite famously used by neurolinguists. One of them is the analysis of frequency bands. So our brains operate at different frequencies. For now, for instance, we operate probably at the beta frequency, right? So we attentively listen to, etc. So we can actually monitor the overall mental state, right? And the cognitive state that we are in at a given moment. But most frequently used method is actually event-related potentials that I will try to walk you through briefly in a sec. Okay, so what we do. Let's maybe imagine that we would like to study how people process negative and neutral words, right? This is our research question. We want to find out the neurocognitive mechanism behind this kind of processing. So first we actually present our participants with those stimuli that are randomly presented, so negative and neutral words. Then we continuously measure the brain activity, and we actually send little markers that tells us where a specific word was presented. Based on those markers, we actually cut those pieces of this continuous data that surround the presentation of our word, and we can assume that the activity was actually evoked partially, at least partially, by those words. Now, the critical thing is that we measure at the same time many things, not just a response to the brain, to those words, but pretty much everything, right? So what we do, we actually average the data across our conditions. So separately we can average brain responses to neutral words and negative words, and then we average it all across all participants that we have in our experiment. So the idea here is that with time, with more and more data, everything that is brain related will survive, and everything that is unrelated, that is stimulus related will survive, and everything that is unrelated to our stimuli will basically cancel out, right? So we will filter out the entire noise, and we will end up with a prototypical brain response to our negative and neutral words. Okay, so now let's put theory into practice, and allow me to walk you through my research. This is the paper that we published together with my colleague Katarzyna Jankowiak this year in Neuroimage. And in this study, we're actually interested in how our current emotional state, whether we're in a more positive or negative mood, influences the neurocognitive mechanisms behind activating gender stereotypes. So what we did, we first actually put our participants into those targeted mood states. So we made them feel sad and happy through the exposure to video clips, like animated emotional video clips. And then we asked them to read sentences. The sentences were of two types. Some of them, actually half of them, were stereotypically congruent. So here we constructed sentences that actually were in line with what we expect from women and men, like stereotypically speaking, right? So we have an example here. So the court granted alimony to the stay-at-home mother. But in half of the sentences, actually, we exchange this critical word so that it's actually confronts the brain with something less expected. We have here we have stereotype violation, right? So instead of putting the word mother, we put the word father, right? And here, a small disclaimer: it's not that we want to perpetuate stereotypical thinking. On the contrary, we want to, as if, understand the mechanism better, so as to we know how it works, right? But definitely, these were like gross sentences, like that weren't very inclusive. So, as you can see here on this plot, in the positive mood condition, what we observed here was larger brain response, so high amplitudes to those sentences that violated gender stereotypes compared to those that aligned with them, right? In simple terms, it means that the brain had to invest more neurocognitive resources into trying to understand what's the connection between like stay-at-home father, because what we expect in those contexts typically is a word mother, right? So this pattern was actually observed in the positive mood, and the difference between the two conditions that we can observe here is actually typically taken as a measurement of stereotype activation. The larger the difference, the larger the activation of gender stereotypes. Surprisingly, as you can see here on the right-hand side, in the negative mood condition, we observed absolutely no differences between the two conditions, right? So what it means, so we can conclude actually that neurocognitive mechanisms underlying gender stereotype activation may potentially be facilitated in a positive mood and suppressed in a negative mood, right? So this leads us to a different context. Now we take EEG out of our laboratory and we'll focus on how it's used in real life, right? So wearable neurotechnology. So again, we have non-invasive devices available to us on the market that use EEG to monitor the brain activity in real life and in real time. And these devices are typically designed for everyday use. So these are lightweight, battery-powered, and often integrated with smartphones and virtual reality systems and mobile applications. So how exactly it works? So basically, those devices measure the brain activity and then provide users with neural feedback based on AI and machine learning, and then they can basically focus better or enhance their cognitive processes, etc. What's quite critical here is that those devices have basically been used for commercial purposes mostly, right? So they are very often used to or help us with focus and attention training or sleep quality tracking or stress reduction or even emotion regulation. When it comes to scientific applications, there were some attempts of trying to use it in research, but not many. The major limitation here is that basically those devices offer lower quality of the signal compared to traditional EEG. That's why it's not yet welcomed with open arms by researchers. Okay. So this slide only demonstrates that all of those devices come in all sizes and shapes. As you can see here, we have headphones with headpieces. Some of them have 2 electrodes, some of them have 32. So actually the market is fast developing here. Okay, so here I just wanted to mention some popular products on the market that use EEG. So we have Muse, for instance, that is used with real-time neurofeedback for meditation training, right? So we can improve our meditation skills using neurotech. Then we have Motive, right? So it helps us to monitor stress, focus, engagement, and interest. There's also NeuroSky, right, which is more targets effective learning, right? So how we can use it, how we can actually change our thinking patterns to learn better. Then we have NextMind, right? So non-invasive brain control, and this is dedicated for augmented reality and virtual reality systems, but also Neurable, right? Helping with productivity and enhancing focus, and very much integrated with brain-computer interfaces. Here I also wanted to show you that on this slide that we have quite detailed stats provided by those devices, but I can tell you as a neuroscientist working with this type of data, I would basically, if I recorded this type of data, I would have to exclude it right away, right? It's not as if measurable, it's not reliable for us as scientists, it's basically noise, right? So it shows that those devices definitely is a thing for future, but at this stage yet, okay, for commercial use for sure, but for scientific use, maybe not yet. Okay, So this is the last slide from me. So this brings us to a big question, right? So this is our topic of our today's debate. So how sensitive is this data, right? So can we actually say that EEG data can be perceived as biometric identifiers? There's not an easy answer to this question. I think Hannah will walk us through many challenges that we might face here, or legal and ethical challenges. But I only wanted to mention that there have been some studies conducted showing that we can actually learn, or we can actually train machines to recognize specific patterns based on EEG signals to identify a specific person. And I was quite astonished when I actually learned that the precision with which machines actually recognize individuals based on this type of data is like 98 or 100%, right? So it's very effective. So I think this is the moment when I will give the floor to Hannah, who will walk us through the legal and ethical aspects.
Yeah, hello everybody. Can you hear me? Is that working? Well, okay, perfect. Well, first of all, thank you so much for the nice introduction, and thank you. I'm too small. I hope you can hear me now. I'm very happy to be here today and to talk about such a fascinating and rapidly evolving technology. As lawyers, we often find ourselves reacting to new technology rather than anticipating it, which leads to some problems and legal gaps. So I'm all the more happy to now be here and talk also about the legal implications of neurotechnology and the devices. As we just heard, the advance of neurotechnology is on the market. We see more and more neurotechnology and neurotech devices, especially in the consumer, when it comes to consumer-grade BCIs. More and more brain sensors are embedded in everyday technology, and even if those sensors are not as good as, because they don't provide, as we just heard, data that is good for scientific purposes, the technology is advancing more and more. We can also see this in market developments. The global neurotech market was in 2024 worth $15.2 billion and is expected to nearly double by 2030, reaching over $30 billion. So this technology really holds tremendous potential for healthcare, for communication, for education, and far beyond. This will most probably lead to a continuous and large-scale collection of what I call brain data, or some people call brain data. And this all can lead to something that we can refer to as big brain data. I'm sure you've all heard of big data. So when we add now brain data, it will be big brain data. And if we combine this with existing data sets, we will be able to do what is called neuroprofiling. That are highly sensitive insights into human behavior, like emotion detection, but also decision-making processes. This all development raises fundamental questions, like how should we regulate technologies that not only track our behavior, but potentially access our thoughts and emotions? But also, how do we build trust in technologies that offer enormous promise and opportunities, but also carry serious ethical risks? So in the next 10 minutes, oh no, I didn't do an overview, sorry. In the next 10 minutes, I will give a brief overview over key legal issues and the current regulatory landscape. This is all a very brief overview because there is so much law involved, but I just want to provide a little insight so we have a basis for the panel. So first of all, why do we need regulation? So the first is to protect fundamental rights. BCIs grant direct access to neural activity, which leads to the question whether we need new rights, new fundamental rights, or if the existing rights are already sufficient. We can already see nowadays that companies use behavioral targeting strategies to influence individuals, to alter decisions, to shape their preferences. This is a way we can see, especially in advertising commercials, that individuals are pushed into contracts that they don't want to. On a political level, I don't know if you've heard about the term nudging. That's been popularized by Taylor and Sunstein. So the idea is that we change someone's behavior without restricting something, without forbidding something, but at the same time we manipulate the behavior. And this is being done by using personal information and by exploiting certain vulnerabilities, certain cognitive biases. This is already working quite well, but now imagine that that companies also have access to brain data, so to insights about actual mechanisms of human decision making. So the manipulation risk will be much, much higher. And that is why some legal scholars and civil society organizations argue that we need a new legal framework, so-called neurorights, because brain data are intrinsically linked to human identity and mental self-determination, so we need special protection. The Neurorights Foundation, we will hear about it later, proposes 5 neurorights. One of them is the right to mental privacy, as the right to keep data about one's mental activity protected from unwanted disclosure. Some countries, like Chile, have even enshrined neurorights in their constitution. Others are cautioning against what they call a rights inflation. For example, the European Parliamentary Research Service came to the conclusion that the rights enshrined in the European Convention on Human Rights and the Charter of Fundamental Rights of the European Union are already providing a suitable legal framework. And if we are introducing new human rights, then we risk to create legal uncertainty and having regulatory gaps. The second reason why we're regulating is accountability and safety. For example, liability law serves 2 purposes, a compensatory and a preventive one. So let's have a look at the first one. If a company, for example, profits economically from a certain technology, it is only fair that they also bear the risks. Also, the responsibility should lie at the person who designs, controls, and profits from it. It's much closer to the actual technology and in a better position to manage risks. On a second hand, it also serves a preventive function. From the perspective of economic legal theory, liability law incentivizes private actors to internalize potential harms and to invest in risk mitigation. Why is that so? Because liability costs money. If a technology causes harm, then the person who causes harm, the company, whoever it is, has to pay damages, but also risk reputational losses, which then costs, again, money. So liability law is a way to really give incentive to integrate safeguards and thus promoting safety through legal foresight. Thirdly, regulation can also foster innovation. Oftentimes you hear that excessive regulation hinder innovation because it makes innovation, the development of technology expensive. You need legal counsel, but you also have to change the design maybe and all the technology. But on the other hand, proportionate regulation enhances public trust and can also stimulate demand. There's been a recent study by the IT Security Research Group at the University of Paderborn. And they showed that transparency and informed consent in particular are the key drivers of acceptance of neurotechnology. So it's also important for companies that users trust the technology in order for them to use it. Furthermore, legal clarity also provides legal certainty because companies can quantify liabilities and also insure against risks. So now let's have a brief look at the already existing legal framework. So far there is no dedicated framework for neurotechnology in the European Union. However, there's a broad set of already existing EU regulation that on the one hand regulates products and on the other hand that regulates the use of data. So this is just a brief overview. It's not exhaustive. There's much more, but just so you can see, there's already like a lot of regulation that will also apply to neurotechnology devices and products, and on the other side, the use and process of brain data. So product regulation is oftentimes sector-specific. If a BCI has an intended medical purpose, then the Medical Devices Regulation, MDR, applies and imposes strict ex-ante requirements, including clinical evaluation, risk classification, and conformity assessment. So that is rather strict. Then we also have the quite new Cyber Resilience Act that introduces baseline cybersecurity obligations for all products with digital elements. So this will also include consumer-grade BCIs if they are connected to a device or network. And the CRA requires that products are to be designed in a way to prevent security breaches such as hacking. And then most significantly, we already heard of it yesterday, the AI Act also apply whenever BCIs make use of artificial intelligence, for instance, to interpret brain signals, to detect emotions, to personalize learning tools. The AI Act follows a risk-based approach and classifies AI systems into different categories, into those with an unacceptable, a high, a limited, or minimal risk. And those systems that pose a clear threat to people's safety, livelihoods, or fundamental rights are prohibited. Those are, for example, AI-based manipulation or deception, the exploitation of vulnerabilities, and emotion recognition in workplaces and educational settings. This will be quite interesting when we come back to the question of is like behavioral targeting allowed or is it not allowed? However, there are a lot of questions, like what does harmful mean? What kind of grade of harm do you need in order for it to be forbidden? And also, and there we maybe need the experts of the technological side, how can we actually know if an AI system is programmed that way? What if the algorithms learn by itself to exploit certain vulnerabilities? So how can we make sure that the AI system is not exploiting or is not manipulating in a way? So the enforcement will be one of the big problems here. And then other AI systems used for emotion recognition, for example, are classified as high risk, triggering, for example, transparency obligations. The second crucial layer is data governance. Brain data is not specifically regulated, but the use and processing are subject to numerous legal instruments by the EU as part of its new data strategy to promote data sharing as a resource for innovation, economic growth, and the common good. And one of the most important, of course, is the GDPR that regulates how personal data may be used and processed. So the one problem is that brain data is not explicitly listed as a separate special category in the GDPR. This is important because the special categories under Article 9 have higher protection than other personal data. For example, you need explicit consent in order for it to be processed. So you cannot agree unexplicitly, which makes in reality a big issue. So the question is whether it's health or biometric data. Typically, brain data will be considered as health data, but this is not completely clear. There's a lot of legal uncertainty. Why is that so? As we just heard, we can get information about someone's health by analyzing brain data, but just because we can get that information doesn't mean it is health data in the sense of the GDPR. For example, yesterday people took pictures at the dinner, at the gathering. Now if you look at the pictures, at first you would say, what's health data about it? But then you see people are wearing glasses, people are drinking alcohol, maybe someone smoked a cigarette or was in a wheelchair. So from those pictures, you can indeed get some information about health, about the alcoholic consumption or about the eyesight. And usually, I mean, this has triggered a lot of problems and legal debates. But in general, the data protection authorities tend to look at the context as well and say that in this case it's not health data because we don't want, or the one who's taking the pictures, who's processing the data, doesn't want to get information about the health. So this will also pose a problem when it comes to BCIs. What if we get information about cognitive states, but the processor doesn't want to get any information about the person's health? So it's not completely clear if brain data will always be health-related or not. And that's why many people say we should have like a special category for brain data to not have this legal uncertainty. And the next problem is that even if we apply Article 9, that triggers many obligations, like the core data principles, particularly proportionality, accuracy, transparency, and fairness. And in the context of brain data, the problem is one that what applies is data minimization. So under the GDPR, you have to minimize the amount of data, which contradicts any AI systems, because the more data you have, the better it is. So this is still an unresolved issue. And also transparency is difficult, because especially with brain data, it's extremely complicated to know what kind of information you gather and what kind of information not. So how can you make the processing so transparent that the consent the user gives is actually free in the sense of the GDPR? Then I see the time. Let me just say very quickly, what's also interesting is the recently adopted Data Act, because the Data Act revisits fundamental questions of data access and control. So before, we had the controller or the manufacturer of a device, for example, a smart fridge, had the control of the data, because he gets the information that the user generates by using the fridge, by using the smart TV, or by using the smart car. And the controller could do whatever he wanted, basically, as long as it was not personal data, because then the GDPR applies. And they used all the data to train the AI systems and so on. And the Data Act shifts this now and says that, first of all, the user has to have access to the data, and also the data controller, so the manufacturer of the smart fridge, for example, can only use that data for training the AI system when the user actually consents to it. So in the context of BCI, this is also very interesting, because now users can actually access neural data And this shift could maybe increase individual agency over mental and cognitive data. But also it raises the question if we as a society want that brain data can be treated like any other, traded like any other good, that it's like considered as something that we can sell and use basically for economic reasons. Sorry. So let me conclude here. Next time I will add some more presentation slides. So let me conclude. We are entering a new regulatory era. Existing legal tools need to evolve and to keep pace with the ethical complexity and the technical realities of neurotechnology. We as a society must rethink what privacy means when thoughts become readable. We must also define how we want to, or decide how we want to treat brain data, and we must safeguard mental autonomy in this new context. Our one panel later today will look more closely at the current laws and will also explore the gaps, especially when it comes to consumer products. And throughout these conversations and debates, I invite us all to reflect not only on where we are legally, but also on the values that should guide our next step when it comes to regulation. Because regulation is not a barrier of innovation, it's what makes responsible innovation possible. And it ensures that progress in neurotechnology reflects our shared values and rights. And now, thank you.
Thank you, Hannah, and thank you, Marcin. And as you saw, there is a relationship between DMA, DSA, consumer law, data protection, and the neuro rights. So everything we talked about yesterday may be applicable for the neuro topics. We're slightly late, so let's reconvene at 11:20, and then we'll have the debate, including also your questions to the panelists. So if there is still anything you want to ask Marcin or Hannah, you can both ask them during the break or during the debate and the Q&A session. I guess we all do have some questions, but let's leave it for later. 11:20, we're gathering back here. Thank you very much.
No, no.
Welcome everyone after the break. One of our participants, Monika Namysłowska, asked me, why do we have so many breaks at the conference? And the answer is pretty clear after the introduction to the neurotech and then the debate. We need to have time to digest everything. And I think that's why we have lunch after the debate, because we need more time after what's going to happen in here. So welcome everyone to the main debate of today's conference day. We're going to cover neurotech, neurorights, and data. And this is also thanks to the Cognitive Neuroscience Center, which is a unit within the Mickiewicz University. Marcin is part of this unit, and we're working closely to develop those topics that are at the intersection of law and technologies. And as you probably noticed, there's more to it than just a device or just a piece of legislation. There's the whole matrix, and today we'll try to cover how this matrix is being formed by different kinds of interests, conditions, needs, regulations, etc. So that's why we're very happy to host a couple of great experts from different fields that are dealing with a common thing, which is the technology. And starting from my left, let me present Łukasz Szoszkiewicz, who is a PhD originally in constitutional law, but recently we would say a neuroscientist or neuro lawyer, also a data scientist himself. Recently finished his scholarship at Columbia University, and currently Łukasz is involved with the Neurorights Foundation as a director for European Affairs. Is that the right title? It's still the right title. It sounds very good. And Łukasz is also a member of our faculty, and he deals with those neuro topics at Mickiewicz University, and he's one of the mentors of, or tutors or promoters of those topics within our community. Then we have Hannah Thornton, who's an expert in brain machine interfaces, and she's also a practicing lawyer, so she knows the landscape of legal challenges very well. And next to Hannah, we have Peter Yu, who's a distinguished professor. If you visit his website and check the number of publications, you'll be amazed how effective a scholar can be. I know the secret to that. Peter told me that he has very little teaching and a lot of research and travels. And this might be one of the reasons, apart from the fact that he is just an excellent scholar. He is a professor of law. He deals with intellectual property, competition, innovation, and many more, and we'll have a chance to listen to his expertise. He is closely related to the American environment, which leads us to another expert, which is going to be in a second presented by me, but then we also have Mikołaj Buchwald, who is a neuroscientist working for Poznań Supercomputing and Networking Center at the Institute of Organic Biochemistry of Polish Academy of Sciences, which is a super long name for a very excellent research unit from Poznań, although Mikołaj is he lives in Brussels in Belgium. And then we have Steven Damianos, who flew directly from America, from the Neuro Rights Foundation. I think we'll let Steven say something more about the very foundation, but we can say that this is one of the few bodies in the world that actually does proactive research in neuro rights, and they're supporting policy making that results in some changes even in constitutional orders across the world. And my last speaker and expert is Marta Pych. She's a lawyer and a representative of the Polish Data Protection Officer, and who's better to ask the questions about the data and the sensitive topics related to the content of data. So you see there's a beautiful palette of speakers, and I will let Łukasz and Hanna run this and moderate this debate, and I'm really looking forward to what happens. And of course, all of you are invited to participate, ask questions, and stop the speakers once you don't agree with what they're saying. I will be with the mic, so whoever feels like I need to interrupt, just raise your hands. Meanwhile, I will let Łukasz and Hanna lead the debate, and let's enjoy this fruitful time together. Thank you.
Thank you, Wojciech. So we've prepared several questions together with Hanna, but we also would like to invite you to raise your hands whenever you think that certain topic that we'll touch upon is interesting and we should dive into it. And we will start with a round of several general questions, and then we will jump also to some specific nitty-gritties of different fields of expertise of our panelists. So, Hanna, would you like to start?
Okay, thank you very much. So we asked the panelists to answer 3 questions, just so we know about their position when it comes to neurotech. So the first question is, which poses the greater threat to consumer neurotech, a Wild West or minimal or no safeguards, or strict rules that can stifle innovation?
Yes, and here is the mic.
There's the mic. And we would ask everyone to just shortly answer, because we will dive into the debate right after.
So is this one on? Yes. Okay. So I think for Wild West is going to be problematic in the sense that you don't know exactly how things will play out. There's no certainty. There's not a lot of predictability. But a lot of regulation, on the other hand, can also be quite problematic, because it can stifle development of technology. It raises a lot of concern about compliance, and it also adds to the cost of the development of technology. And for those of us who are working on technology law, intellectual property, we're happy, right? Because we have to deal with all different problems. We help you find answers. But for those who are business decision makers, that always a major constraint.
Yeah, from my perspective, I think the regulations are needed, of course, because they address our concerns regarding the data, because we as a human beings, we are also potential source of this data. So for example, if you have an MRI of your brain, you don't want the information to leak out, to disclose the state of your health or of your cognition. And yeah, definitely the rules are needed, but I wouldn't say that the strict rules are needed, strict laws, but the relevant ones, the pragmatic ones that just help us with the flow of developing new technologies, and those laws are guiding us to cover our concerns. They should not be obstructing our work. They should be helpful.
I would agree and note that the Wild West is something that poses a threat both to consumers and to the consumer neurotechnology space more generally. And this is something that Hanna mentioned in her remarks earlier, that actually regulation is something that can promote innovation and build public trust and safety in the space. And so in order to ensure that neurotechnologies can actually effectively have adoption and have the public say, yes, this is something that we are going to buy, that we are going to lean into and integrate into our lives, there needs to be a sense that this is something that I feel comfortable using. And so therefore, in order to ensure that the consumers are adequately protected, and also that the consumer neurotechnology market itself is something that can take off. Regulations are necessary.
Well, from the perspective of regulatory and supervisory bodies, so much rooted in the legal EU system, so the precautionary principle, right? I would say Wild West scenario, like something we cannot allow to happen, because we are talking about human rights. But there is always this dilemma when and how to regulate to make it efficient, to make it truly protect human rights and allow for innovation. And I think we would opt for clear rules to provide legal certainty, but also we can have some mechanism allowing market to innovate and give them more accuracy in terms of like self-regulations. I mean, for example, GDPR certification is an interesting mechanism, that term, or regulatory sandboxes. So there are mechanisms that could allow for more innovation in more stiff regulatory frameworks, I would say. Yes.
Thank you. We can go the other way around maybe this time. So if that's okay. So 2 more questions. The one question is, do you think that brain or neural data should be treated as a special category in the sense that it is more sensitive than the personal data we already have and the information we can extract out of that? And what do you think will happen in 5 to 10 years? Where will the technology be? What kind of information can we gather it? And will consumer technologies primarily empower individuals, promote social equality, or become an instrument of control?
Well, that's a good question. I mean, from the perspective of Article 9, GDPR, it's interesting to have this differentiation between mental information and neural information, because mental information would be always like revealing mental states of mind, and like neural information can be more related to health data. But it's still difficult because we lack this specific vocabulary, like the specific word neural data in Article 9. I mean in Article 4, but like relating to Article 9. So yes, this is a challenge, definitely. But also relying more on like legal intuition, I would say it is very sensitive. Like coming from the mind itself, it's definitely something more than regular data. And then the category of like sensitive data is it's not the same as like special categories of data recognized under the GDPR. So here perhaps there is more need for legal certainty. Yes. And the second question, could you repeat, was about...
Yeah, what do you think will happen in 5 to 10 years with the neurotechnology? Like, what kind of potential does it have?
Well, it's difficult to say. I mean, it has a lot of potential, especially in health regulation, in, for example, like prevention of mental problems, health problems, definitely. I wonder whether the consumer applications wouldn't be the problem, because then it escapes a little bit our frameworks, because we have good frameworks, I think, right now for the health data protection, and one that allows also some more innovation and like use in research, for example, with HDS. But when it comes to neural data that are not health data, it's difficult for me to tell, because we have to see what the application would be, and then we have to keep in mind, I think, the privacy by design. And I really hope that this system would be developed having in mind privacy by design. So then we can imagine having this privacy very much in the design, in the filtering of data and pre-processing. But we'll see.
So on the first question around the data classification, I have the stance, and my colleagues at the No Rights Foundation share the stance, that neural data are a unique class of data that are uniquely sensitive in terms of what they reveal, and that this is a distinct class of data from genetic data or from biometric data and need to be treated as such. And also, logically speaking, if you would say, yes, my geolocational data are sensitive, or yes, my financial data are sensitive, certainly you also would want this to be a class of data that are treated with the heightened and most possibly heightened levels of protection as well. So happy to speak to more of that in the discussion. But to the second question around, something I've learned, especially as an American with our political landscape, I don't make predictions about what happens, and I don't do it publicly. So I will not make predictions about where the science is going, because I'm also not a scientist. But I will make a prediction and say that the technology, which now is somewhat fringe and becoming more mainstream, will become deeply embedded in our lives and in our societies, and will transform the way that we relate to ourselves and to others. For example, Apple has a patent from 2023 on next generation AirPods. I'm actually just curious, how many people in this room use AirPods? Okay, so that's 75, 80% of I'm on the panel, I have them in my pocket, and so there'll be EEG scanning technology in one of the next generation AirPods from Apple. I think it's around 150 million users or so with AirPods. Not to say that the next generation will have that number as well, but right now we might say, okay, yes, those devices look cool, brain science, but what does it have to do with me? But I think as these technologies drop and are commercialized by some of these big tech giants, Apple, Meta, and others, and also as we see neurotechnologies implemented in the workforce, even sometimes in ways that are required to have a certain job, and this changes the future of work, or in athletics departments, and as we try to understand how to cognitively enhance or have mental augmentation in that space, suddenly something that seems kind of future-y and fringe is going to become deeply embedded in the way that we live our lives.
So to answer the first question regarding if the neural data are special kind of privacy category, then I of course agree that it's important to protect those, because those relate to our mind, which is something very important and close to us, to our cells. But now I want to say something more controversial, maybe, because I understand that the regulation, the policies should always precede the technical capabilities. But the truth is, from a more technical perspective, I'm not engineer as such, a pure engineer per se. I know about engineering, but I consider myself more of a researcher. But if you had a real engineer here, from technical university, then he would tell you that the technology is not ready yet to get anything that specific from neural type of data. I mean, of course, it can to some extent predict some very pronounced cognitive disorders or neurological disorders like epilepsy, yeah? Or very evident glioblastoma cases in MRI. But for most of us, I would say that the amount of information that you can get from those data is not that different from the ones that you can got from the heart or from the liver, because there you also have some physical damages or pathologies that can tell you about something about your health. So I think, yes, it's very important to care and put a special care for this data, but for now, more because we perceive such data, those data as such, as important for us, not for the reasons how much information we can get from it. The case of Apple is interesting, and then they are putting the EEG there, but maybe we can come back to this in the discussion, because they were also putting algorithms for detecting heart issues, potential heart failure, and scientifically, technically, it doesn't work that well. So only because they are saying that they will do this doesn't mean that it will be valid and will be within 10 years useful information or dangerous information to get something out of this kind of sensor on mass scale from billions of users. So this brings me to another question about what we can say today about the consumer-grade neurotech and how it can influence the society. So I don't want to prolong my part, but I think an interesting case is Neuralink, which is maybe not a consumer grade yet, but it's a state of the art, despite all the controversies around the ethics of those devices. And I was for 1 year a postdoc intern at Cedars-Sinai Medical Center in Los Angeles, in the country of gentlemen on my left and right. So I participated there in some scientific meetings with people who are developing similar technologies on animal models, for example. So brain-computer interfaces with arrays of electrodes, which are similar to those developed by Neuralink. So they told me that, okay, Neuralink has better tech because they have more money, more funding, so they can hire the best engineers who are willing to work for them. Yeah, so overall, the mass that they have, critical mass, is bigger. But in terms of the clinical trial that they are running, it ends and concludes like 2031 or 2035, something like this. So if the state of the art is going that fast, then consumer grade will not be faster than this. And so breakthrough technologies are getting there, but I think that the perspective of 5-10 years, it will not be groundbreaking yet. Maybe I will need to revise my forecast soon. But anyway, so for now, those technologies are changing how we perceive the brain and how we perceive our mind. But more, I think about raising the awareness. So if you have an EEG consumer grade, which helps you to meditate or which helps you to focus, it's important for your mental part also. So you're getting interested in your brain and you do meditation, and maybe this meditation brings you more actually than the technology that is there. So it's influencing us, but I don't think directly in the ways that we think it does. Thank you.
So I'm so glad I go last. This is a hard question. So I think the instinctive answer is neurodata have to be special, right? People always are very concerned about the brain or the mental process, right? You can operate on my arm, you can operate on my knee, but just don't operate on my brain, right? I think the other reason is probably that people don't know exactly how we think, right? They fear that you might actually find something that is subconsciously within your brain, but at the same time, you have not expressed yourself in a certain way, and you don't know what you can find. And I think from the regulatory standpoint, it's also important to think of, for example, mental privacy as a new frontier, right? So there's a lot we don't know exactly how we're going to develop the governance framework or how we're going to apply it, fundamental rights or human rights, or what type of legislation will be out there. But I think when you think a little bit more, I think the counter argument is that, well, we can actually infer your thought process from a lot of different data they've collected about you, right? So the concern is actually combining the neural data with other data that's out there so that you can actually draw more conclusions or come up with policy that will discriminate against people based on the different ideology they have. I think that is a big concern. With respect to how we will look at it from 5 years from now or 10 years from now, I think Hannah's question actually adds to a temporal dimension that we didn't get to in the first question, right? So I think the regulatory environment we're going to develop will likely change depending on stages of development of neurotechnology. And a lot of that depends on consumer behavior, right? The more people are interested in having technology, the more people want to have convenience, right? So Stephen asked earlier about the airport, right? So this is the more people actually want that type of technology, the more we'll assess the risk differently. And if we assess the risk differently, then we'll also have a different regulatory environment. And obviously, this chicken and egg, right? The regulation can affect what type of technology is actually being placed on the market. But at the same time, how consumers prefer the products and what type of compromise they want to strike in the regulatory environment would also affect how we're going to control that technology. So that will be going to be quite interesting. But for those of you who are basic students here, I can tell you whatever you learn in law school about technology, 5 years, 10 years from now is probably not there. Right, so you better actually learn about how to apply the theories, how to apply the thinking process, how to think like a technology lawyer, as opposed to thinking about what you do with that particular technology, because it probably won't be there.
I think it's interplays with my question, which I have to you. So drawing on the regulatory debates around other technologies like genetics, like AI, what key lessons should inform today's policy making on neurotechnologies, and do you see any specificities of the technology or regulatory landscape that are unique to neurotech? For instance, we have genetic data. You obtain genetic material once and you have full data. With EEG, for instance, you are collecting in real time. It's changing, so that's continuous inflow of data. So there are probably some differences. But what's your take on it? What can we take from the lessons that we learned regulating other technologies?
I will pass my mic to this side first, and then I'll come back.
Sure. I have no time to think of an answer, but so we'll just word vomit something out. I have a mentor who always says to me, never let a crisis go to waste. Or never let a disaster go to waste. And I like that in terms of what can we learn from something that went wrong. I think that the way that people responded and society responded retroactively to AI and to AI governance, and also where a lot of people, I think it was a Microsoft executive who publicly said, we shouldn't regulate AI until there's evidence of harm, which means let's wait for someone to get hurt and make money until then. That approach, I think, should, whether it's related to neurotechnology or other technologies or anything in life, any policy intervention is not the approach to take. And so, and again, neurotechnology is not as widespread yet in the consumer space, but companies like Muse and Emotive already have each around 17 million minutes of EEG data that they've collected from consumers, and data sets are growing and are amassing, and so. In terms of the timeline and of whether this is something that is a today problem or a future problem, we come up on this question a lot in our work of, is this something, are we talking about the future or are we talking about today? And I would say that something we can learn from other efforts and other technological regulation regimes is that this is something that we already need to be working on, and we already need to be building the infrastructure today so that we are prepared when it really is something that is in front of us in an enormous way. I don't know who wants to jump in.
Yeah, so thank you, Stephen. I want to just refer to what you just said, and I want to bring a case of regulations for AI. So, for example, Google is developing its profiling algorithms. Okay, so they have very nice way to put you a new YouTube video which you are willing to click and watch and learn something from it or just get some information. And the problem with not regulating this, as Microsoft or other big tech corporations would want, the problem with this is that the social factor is being lost. So in the interest of the company is that the person watches more and more of those videos and uses and watches the adverts and stuff. So they have no business case to prevent people from excessively watching something, which is very dangerous for the society, because a lot of us, we are, like us sitting here, we are quite resilient, but we need to remember that there is vast part of society, us included also, yeah, sometimes, that we are prone to those subconscious profiling, modeling. That's also a bit what you, Peter, mentioned, yeah, about the risk of using our data against us, not only the neural data. So coming to the AI regulations, what EU is doing with laws like AI Act, they want to prevent this. So Europe wants to prevent its citizens from unlawful and wrong use of technology, which I think is a great case. Yeah, when I was in one of the meetings in Brussels, I met people who are working on audits, ethical audits for AI models. So it's an amazing idea. So if you have an AI model for profiling, so profiling can also be good. Yeah, we can get some information that is useful for us, but up to a certain point. And how can we determine where this point is? So you need the regulatory framework, and then you need people who are actually enforcing it and checking if the technology is being delivered, if it actually is not causing harm to the society. And yeah, similar approach can be used for neurotech, I think.
I agree that experiences we have with AI and developing regulatory framework for AI could be very useful. I think for us also it's a great lesson not to respond too late, because I think it's that's the dilemma of regulation. On the one hand, we would like to be always very active, and especially in the areas that concern human rights, and that can, to a certain extent, produce this irreversible damage. We want to have active response. But on the other hand, regulating too early can have the opposite effect, because we don't know how the market would react and what direction it would form. So this is the dilemma I think we have right now. And in the meantime, perhaps we can use what we already have. I think we have some good frameworks. Definitely, EDPB is now more active in the area of pseudonymization and anonymization, so those could be interesting in terms of neural data, because could make it easier for the researchers, for example, to use. We can also apply a little bit of this logic from the opinion 28/2024 on AI models, because even though it does not apply to neural data, obviously, it shows a little bit of this logic of supervisory authorities when dealing with new technologies and dealing with potentially disruptive technologies. So definitely we can start building from what we have now, a little bit twofold approach, building from what we have now and keeping in mind that perhaps we will need to build this manpower for new regulatory frameworks. So it's interesting. Interesting topic, and we'll see how it will shape our society in the future. Yeah.
When we think about cutting-edge technology, whether we are thinking about AI or neurotechnology, I think the challenge is what we usually describe as the pacing problem, right? So when you want to regulate, you don't have enough information as to how you're going to handle that, but by the time you get information, it's too late. Right, so I think this is always a challenge for any regulators trying to deal with new technology, and we have seen this playing out with respect to AI technology. It's a moving target. Whatever those of us who write about, for example, intellectual property and AI 2 or 3 years ago, now the landscape has changed, right? So we're just basically playing catch up all the time. One thing that we can learn, especially in light of the development of the AI Act here in the EU, as well as in other places when they have the different regulation, is that how much the public think about AI technology can actually affect the debate, right? So a lot of those provisions, for example, about intellectual property, did not get into a debate about AI Act until very late, right? And that is in part because a lot of people start talking about ChatGPT, people are using Midjourney, people thinking about stable diffusion, and all of a sudden they start asking questions. What if do you have works generated by AI? How are you going to regulate that? Are you going to have something similar to Article 53? Are you going to add some of the issues about the product being trained in Japan, in Singapore, in other parts of the world? Right, those things get into AI Act much later, and you end up with a situation where you have a lot of things about intellectual property, which is more on the private law side, and yet you have the AI Act actually structured as product safety, risk, more on the public side. Right, so I think that type of challenges we are going to see, and is something we can learn from AI. The other lesson I think we can also learn from AI is what the UN has been focused on quite a bit, is the AI divide between the global north and the global south. So I've been traveling quite a bit to conferences in different parts of the world in the last 2 or 3 years. And sometimes I get into countries and I feel that some of the conversation I have had with my colleagues in the US or when I come here in the EU is completely irrelevant to the local conditions. They do not have enough computing resources. They lose a lot of human talents because anybody who knows about AI get heavily recruited away to work in foreign companies. And they also do not have the meaningful training data that can actually help them develop something that is useful locally. Right? So there's a huge gap between what's going on in global north and what's going on in global south. And unfortunately, I suspect this will also be the case with respect to neurotechnology. Right? A lot of the things that are actually being put on the market here, elsewhere in the US or within the European Union, I suspect that that might not necessarily be the case for a lot of developing countries. Right? So at the international level, we also need to think about the different type of development of different type of international regulatory framework we need to develop.
Thank you. And we have a question from audience.
Thank you very much. This is so exciting. I mean, this issue. My knowledge regarding this sphere is very limited. So please, could tell us what companies are leading on this area, and whether these companies are the same which own now the AI technology and quantum technology. And if this is the case, could you do for us the math, and could you add these dots? If we have the companies which own the AI technology, the quantum technology, and the neuro stuff technology, what will be then at the end? Should we start thinking in the Skynet as a Skynet from Terminator? I mean, with all due respect, of course, because now I'm really curious that you are talking about these regulatory aspects, but we are not thinking about the threat of monopolizing this technology. This is my first question. Yeah. Thank you.
Thank you. Who would like to answer? A very important question.
Yeah, I can try to address this. I mean, regarding the companies that are developing neurotechnologies. So I think, Hannah, you had a very nice review of those, so maybe you're more qualified at this moment to comment on this. I mean, I myself, I know the landscape, yeah, but I myself focus on Neurotech, which is software, which is for data analysis, specifically in medical area. But I'm aware that there is a lot of consumer-grade EEGs. FNIRS is an emerging, let's say, potential consumer-grade devices, so we can dwell into, for example, the companies that I know. Maybe, Hannah, you will address this better, but I would like to comment on the second part about the threat of monopolizing neurotech. And from what I know, the companies that are focused on AI, they are not working on neurotechnologies. I mean, maybe the Neuralink is one of the exceptions, yeah, because Elon Musk has holding of different technological companies, because Tesla is also being considered technological more than just a car manufacturer. So this is the exception, but the goal, I think, the conscious goal of those companies is not to monopolize. So neurotech is something still a bit niche, so the companies doing this are doing only this, or mostly this, and the doom scenarios like with Skynet, I don't think we have to worry about this right now. I mean, the threat is not imminent. Not yet worrying. I would start worrying in this 5 to 10 years or so, seeing about how the technology progresses. Because now the AI was introduced, but it was really recently. So now we would need to wait to see the pace of development, how AI could potentially shift the balance of power and to increase the development R&D within the neurotechnology. But from what I'm observing, other panelists can correct me if I'm wrong, it's useful to have AI for neurotech, but it's not that we will have something threatening our society as a whole within 10, 15 years even. So the threat is a bit further, and now we should, I think, focus on the development of technology and observe this. Sorry to disappoint you.
Maybe.
Yeah, so the biggest concern for me in response to Damien's question is not so much who are the players at the moment, right? Is who will end up buying the players at the moment, right? Whether you actually will have concentrated power with respect to certain companies, right, that raise the questions you're talking about. And I think I can see two scenarios, right? One scenario is that they go in different directions. So we have seen companies getting replaced by others, right? So if you actually go back to your old days, for example, when I was in law school, Google is not the same way as it is, right? Same thing for Meta, right? So you can see companies being replaced, and then you have companies that are doing neurotechnology and they are not acquired by others, they can become very big, right, is one scenario. And other is that, well, they are just cut off at the startup stage after they get enough capital and then they got bought up, right? Then they basically, the big technology giants will basically take over, right? That raises the concern you have. And I think the standard response is that, well, then is the time where competition law should play an important role, right? You bring in the people to actually try to address whether we are actually concentrating power too much in certain companies. I think the difficulty, though, is that a lot of companies, and I think that's true with respect to AI, and that goes to the earlier question, a lot of countries actually just want to compete. They want to have world leadership. They want to be able to get the freedom to allow their own technology companies to actually be leaders in the world. And so breaking up the companies is probably not the best way for you to actually become the world leaders, at least based on the what I call an AI nationalist perspective, right? So you want them yourself to become that. And if that is the case with respect to neurotechnology, I can also see a lot of hesitation from regulators to actually step in, because if the goal is to actually allow your companies to become international leaders, right? You want them to actually develop as quickly as they can. You can want them to get as much power as they can, and then you leave those issues to be addressed later. Right, so that would be the concern.
Maybe one quick comment to the question of monopoly. When it comes to the data economy, this is one big issue, that big players, big platforms have all the information and all the data and can basically do whatever they want with it, because we do not have a concept of data ownership, like I'm owning a table. And this is why the European Union addressed this problem, and this is why the Data Act and also the Data Governance Act, when it comes to public available data, is there, because the idea is that data should be a common good and that it should be shared and be part of the economy. So this is one thing that it's at least in the European Union addressed, and will help to share data more and make it available even to smaller players, also startups, that they can make use of it and not the big platforms just gather all the information, and then the small startups don't have anything to, for example, train their AI models.
Just also a quick note, there was example of Apple AirPods, and Meta is also investing in this kind of technology. They are developing neural wristband, So it will be a wearable that you're wearing on your wrist, and it's detecting electrical signal that goes to your muscles there. So there are at least 2 big players that are very much interested in this new source of data. So anyone else would like to comment on the monopolies and startup? And regarding the landscape of companies, actually this week the Center for Future Generations published a report in which they analyzed 271 neurotechnology companies across the world. Approximately half of them are US-based. Approximately half of them are producing consumer-grade neurotechnologies. Another half is producing manufacturing medical devices. So this is how the market looks like, and that's probably the most up-to-date source that I would refer to for market analysis.
In Poland, do we have any?
Yes, there are 7 in Poland in the report, 7 or 8. So that's an average EU score actually in the report, I would say. So in Germany, in Spain, there is comparable number of companies. Yes, we have a question.
Just to refer to Damian's question, so it seems that there's no imminent threat of monopolization. The market is emerging. There are a lot of companies challenging themselves with their products or services. But would you then rather say that what we observe, what the companies are trying to deliver or promise to us is rather a marketing campaign? Like when I hear and read about generative AI, there are a lot of comments suggesting that they are just trying to sell us something and they are exaggerating in the promises. So marketing. Would you agree with that?
So if I may address, if I get you correctly, so I would say from my perspective, observing the market as also potential user in our projects of neurotechnology, so the big players tend to go more into the marketing scheme. So yeah, they need to be very inventive and innovative. So they are throwing big announcements, big words, but who is actually doing something that is being used are those neurotechnologies which are smaller. So the range of consumer-grade wearables or headsets or bands is smaller. And the medical technologies, I would say, those are also smaller companies. So for brain stimulation, for developing new types of new generation types of EEG or FNIRS devices. So from this perspective, so marketing, I think you may disagree, is more of a domain of the big technological players. There we need to filter the announcements more. But if you are looking for something reliable, then go to a company which is present on the market in Europe or in the US and Canada for several years, that they have reliable products that are being used in clinics, because those guys are, of course, they are doing marketing, but for good products, for good stuff that they are working on.
I think we are asking also this question within the NeuroRights Foundation. So I guess that Sven will have some interesting remarks.
Yeah, thank you, Lukasz. So I slightly disagree in that I think there's an enormous amount of deceptive advertising and claims that are not rooted in science in this space. Claims everywhere about at-home treatment for depression. You'll fall asleep within 5 minutes and wake up feeling refreshed. No need to drink coffee anymore because you are so alert and you can hone your focus immediately. Certainly some of these companies are better than others in terms of bringing you to peer-reviewed studies about what the products do. This is not an endorsement of the product, but there's a sleep aid device called Elamind, which the CEO describes as a brain jammer in terms of if you kind of spiral at night before falling asleep and have a hard time sleeping, it helps you block that. And their product is actually quite validated scientifically, but a lot of them are not. And it's a space that consumers walk into with generally no understanding of how the products work and no ability to meaningfully discern what is science and what is just a marketing campaign. And so I think in some cases they will work, or they'll do something. In other cases they'll do nothing. And while you think you're treating your depression over the counter, the company is happily collecting an enormous amount of data about you. And maybe there's also a placebo effect with some of these products, and that could in its way be good as well. But actually our research at the Neurorights Foundation recently led 3 prominent US senators to ask the Federal Trade Commission to launch an investigation into deceptive advertising in this space. So hopefully there will be more information about this soon, and our team also is hoping to conduct a comprehensive study looking at the extent to which companies do or do not validate their claims with science. But what you've raised is something that I think is a big concern.
We have another question from audience.
I like this role.
I think one of the big questions is regulation promoting or hindering innovation? And you touch upon that. And so when we look at what has been regulated, AI, it's risk-based approach that is, I feel like maybe fitting right now, but I'm not sure if it's fitting in a couple of years. And so the law is always a little bit behind, I feel. And another keyword has fallen, which is like regulatory sandboxes. I have a big question mark. What is it even? There's so many forms and things out there. Is it suspension of regulation? Do we alleviate regulation for the first couple of years and see what they're doing? Is it until harm is happening? And how do we transition from this maybe non-regulatory space or sandboxes to the regulatory space? So I feel like there's a lot of questions, and so many are based on, at least from the AI regulation, liability, and not so much on product liability more than human rights, etc. So it's a complex question, but I feel like there's some. I would love to hear your thoughts on that interplay.
Well, so I'm sorry to disappoint, but I think I have the same questions actually, and we as supervisory authorities also have the same questions. Still we have to see how AI regulatory sandboxes works. We see some hope in that, but also there's a lot of uncertainties. So definitely, when it comes to other aspects of regulations, I also wonder about market maturity, because I think market has to mature to feel compliance as a value and to treat compliance as a value, as a trust building. Union legislation recently relies a lot on this soft compliance mechanism, self-regulation, etc. And we have to see whether there is a willingness from the market to invest into compliance, into trust, and that could be pivotal for the neural data regulation, because with such a rapidly evolving fields of regulation, then the hard regulatory response, yes, we can do that, but we still need to build our capacity, and in some way we have to cooperate with market to have this capacity building or understanding at least what we regulate. So that's a big challenge, especially from the human rights perspective, because for human rights we would like to have clear answers. We would like to have this clause to actually enforce, to actually protect, because for us the most important aspect are data subjects. So people, their data, the impact processing has on people. And for now, it's difficult to envision this impact. So I absolutely agree that we are, well, our discussions are dominated by uncertainties, and yeah. So I couldn't offer better answers, but we don't have them yet, I think.
can just add quickly regarding innovation. At the No Rights Foundation, we've been involved in kind of the first policy interventions and legislative frameworks in the world for neurotechnology. And in none of those settings have we run up against opposition from companies. In two of those settings, there were industry lobbyists who were opposing the efforts, but not actual companies. And for example, the CEO of Emotive, Tan Lee, the CEO of Neurable, and a bunch of others are actively involved with these efforts as well and want to be seen as leaders in this space. Now, lest I pose too rosy of a picture, what we're currently proposing with our policy interventions is so narrowly tailored such that it is not threatening the business model of the companies. And certainly if we were proposing a form of regulation that ran contrary to the business model, it's possible that our industry partners would quickly fall away. And so we'd have to see, but then in terms of the pace of regulation, I think one of our approaches that we foreground also is that something is better than nothing, if it is something that's carefully thought through and tailored, of course. And so there will need to be some regulations and safeguards that develop as the technology develops. But for now, we work with what we know and what we have, and we know that the data are entirely unregulated and that today they can be and are sold to third parties, governments, militaries. And I'll also mention, we haven't touched at all on this panel about military actors or kind of law enforcement and criminal justice applications of neurotechnologies. And I think that's a really important space to consider as we think about how these technologies exist and proliferate outside of medical settings. But I'll leave that as a side note. But right now we know that these data are not regulated at all, and can be shared with insurance providers to change your premium, can be shared with employers, potentially leading to workplace discrimination if the data reveal information about your mental health diagnoses, your neurological health, or as technologies increasingly become able to decode aspects of your speech or thought. And so I would say it's trying to figure out also what is necessary and needed now and what do we have the evidence base to legislate from, as opposed to something that is overreaching, which I certainly think would stifle innovation and kind of lead to some sort of backfiring.
So the two common ideas people usually throw around, one is what you mentioned, regulatory sandbox, right? The other is precautionary principle, right? But regardless of what you do, if you come up with a regulatory sandbox, you still have to decide on the boundaries of the sandbox, right? So you want to create freedom so they can play with the technology, do all different things, but you still have to decide on the boundaries. Same thing about precautionary principle, right? You want to basically take a precautious approach whenever the risks are unacceptable. But then you have to get into what type of risks are unacceptable, right, before you can actually get into that, right? I think those are the regulatory techniques that people use, but the hard questions are still being asked, right, as to where would we stand, where would we make compromise, right? So going to what you mentioned about human rights, right? So the three things I may think of when I was asked to do this talk. One is right not to disclose your thoughts, right? I think that would be an important part of human rights. The other is right not to have your thoughts manipulated, right? So the first one is more about mental privacy. The second one is more about mental integrity, right? So you don't want people to do experiments on the thoughts. And the third one is probably rights not to be penalized, right, for your thoughts, so that you not be able to lose your job because of political ideology or sexual orientation or religious thought or something like that. Right, and then you try to fit into what we currently have with respect to the different human rights instruments, whether it's at the international level or at the regional level. We go to right to privacy. That's in the UDHR, that's in the ICCPR. You go to freedom of thought. Right, that's also in both instruments. You can get into self-determination. You can get into non-discrimination. I think mental integrity is actually not in any of the international instruments, but it's in the EU Charter. So it's actually Article 3 right there, right? So you can actually play around with all this, and if you got nothing else, you can always go to the basics to go for human dignity, right? So there are so many ways you can actually play with, but ultimately you still have to ask the question, right? Are you going to extend the current protection? Are you going to go for what Stephen mentioned earlier on, push for something that is new, form of protection because data or neurotechnology is just special, right? You need to actually do somewhat differently. And I think those are the difficult questions we need to ask. And then on top of that, one question that comes up quite a bit for me when I was doing AI research is that, are you guys here in Europe concerned about that you have so much regulation to a point that you stifle technology? But I also ask the same question to my American compatriots. Are they concerned that they are not doing as much regulation so that they have a lot of unacceptable risk, right? And I think those are the difficult questions that we need to ask, and there's no easy answer to strike a good compromise. And on top of that, you also have China with a heavy participation from the public sector. Right, so the type of technology that's coming out from there will also be very different, and that's why I think a lot of the academic commentators are now looking at EU, US, and China in terms of different technological models. I know Bradford is one of them, but there are also quite a number of people, and I suspect that would also be the type of regulation people look at in terms of neurotechnology.
If I could raise one issue, which is not directly related to the question, but I wanted to mention it anyway. So I understand that now I will be boring and going into details, but understand that protection of our minds and thoughts and way we are manipulated potentially, those are very, very interesting subjects for regulators and for our discussion. But going to the everyday development of neurotechnologies or algorithms that are using the neural data, I have one, for example, small issue that is present since years, and I think it will be still there. So in one of the projects we are working on, we want to develop machine learning and potentially AI algorithms to support radiologists performing the description of head MRI scans. So the idea is quite interesting. The leader of the project is a private clinic which has patient data, and recently, just like last week, we had a project meeting, and the lawyer and the attorney for the company asked us, okay, we have MRI scans, but when I look at this scan, the lady said, I can recognize myself from this scan. So is anonymization by just removing the patient data, like identification number, name, surname, is it enough to fully anonymize the kind of data? And in neurosciences, this problem is present since the beginning. People started looking at MRI scans of the head and started asking this question. So sometimes it's further anonymized, for example, like by removing the skull, because the skull is not important for us, it's the brain tissue, yeah? So the front of the skull is removed to further anonymize the image, the data. But is it needed or not? This is not regulated. As far as I know, it's not regulated anywhere. And it's a very simple thing. So if it's hard to regulate such a simple case regarding the data, processing of the data, the neural data, so yeah, it's I think much harder to go further. Or I'm thinking wrong. You can correct me if I'm wrong.
And may I have a question to Marcin? Do you come across similar or same ethical questions in analyzing EEG data? So the kind of data that you described in your presentation.
So actually it's quite fine that you should ask this question, because I wanted to ask a very similar question and share my ideas about the same thing, because I wanted to change the perspective slightly from consumer market to scientific research, because of course we know that consumer market is a big issue here in this particular topic, because the consequences are large scale, potential consequences are large scale. But if you think about research actually in the way we process data, it's actually even more threatening to some extent, because there's like a big movement towards opening our data, right? So we are encouraged as scientists. I do it myself as a data steward. I encourage other scientists to open the data publicly so that it can be reused, so that we can, save resources, so we don't have to repeat exactly the same experiments all the time, etc. But the big question is, when I reveal my data, I make it publicly available, anybody can use it. Of course, it's meant to be used by other scientists, but it doesn't have to be, right? So, yeah, that was a part of my question, whether this is a potential threat that should be regulated as well. Because if you think about it, it's even more specific than random data collected by like those wearable devices, because these are random situations in which something was tested. Today, actually, I showed you some data from our experiments about stereotype thinking, which I think could easily be used in political settings, right? Whether people actively think about others in this stereotypical manner or not. And if I shared this data, I could also we typically also include demographic data. So the data per se is anonymized. Actually, Mikołaj mentioned that sometimes we can question to what extent, but what you can learn is that we have women of a certain age living in a big city in Poland, right? So if you think about it, you can draw many conclusions from this type of data, which is well described, we have lots of metadata included, and potentially, I know, these are like 40 sets, right, of data, but if I collect data from for many experiments, I do the same stuff, like mood stuff, right, so I can actually reveal data from hundreds of participants. So actually I wanted to ask you whether you believe this is something that should be regulated, whether it's equal threat or it's not threatening. How would you compare this to the consumer market?
One thought I have is that, to me, I have less concern with where the data originate, as long as they can end in any world that produces some sort of misuse or harm. And so what I think is insightful about your question is that you are chipping away at some of the boundaries that sound really firm, but maybe are not. Between the medical or the scientific community or the consumer space. We already see some mixing of those areas with the medical versus the health wellness space. I mentioned before about some products that are designed for mental health, and so there's blurring already between those categories. I also, correct me if I'm wrong, Lukasz, but I think some of the legislative efforts around neurotechnologies have explicit exemptions for scientific and medical research purposes, and so that exists, I think, in almost all of the the efforts around the world. But I think you're right to raise that, and something we've also been thinking about is what would an open neuroscience look like? And of course, there are efforts around open AI research, and what does that and should that look like when it comes to neurotechnology in the consumer space and in the research space? I don't know if any of my fellow panelists want to add on to that.
Yeah, this is a very interesting question also, I think, from the perspective of data transfers, yes, because if we have data originating in European Union, then there are limitations on transfer of this data. So that's something to keep in mind, especially, okay, we still need to answer the question whether those data would be personal, would they be truly anonymized, because that's also, we still have we still have so much uncertainties. For example, with the Breyer case, there is this definition that refers to practically impossible or requiring disproportionate effort in terms of time, cost, and manpower. But time, cost, and manpower in the market is always evolving. So what now seems like disproportionate effort in few years can be possible. Well, so that's the question. Another question, I think, would be going back to transfers. So then what transfer safeguards we would have? Because within the European Union, there are some attempts to open this scientific data and to make it more accessible across Europe. So I think opening this data is in principle good in the terms of innovation and research, but in the union legislation we have this specific safeguards. So the question is about safeguards, I think, and mechanisms. I think maybe we will develop, in terms of personal data, a proper mechanism for such transfers. I think in this term, certification could be really interesting as a transfer tool, because we, in the Article 25, certification is explicitly mentioned as the way to demonstrate compliance with the privacy by design, which I think, like recently looking at the regulation at the EU level, it plays more and more important role with new emerging technologies to have this privacy by design. So then, yeah, certification as a transfer tool could be interesting. For example, to have transfer of this scientific data, neural data to, for example, first countries from the US, and having a proper appropriate safeguards. Yeah.
Maybe just one very quick reply. I think this is a very great question to see why we need interdisciplinary panels and research, because I think the GDPR kind of answers that. I don't think we need new regulation when it comes to it, but I think one of the biggest problems is pseudonymization, anonymization, because it's getting extremely complicated to properly anonymize, because just as you said, you have metadata, you have AI systems, and then all of a sudden with existing other data sets, you can re-identify persons, and we don't know what will happen in 10 years. We don't know what will happen if we have better technology and stuff. So I think this is something that on the technological side, people have to think about. How can we actually enforce privacy by designs and other safeguards in order to comply with the GDPR and other acts?
If I may have a question for the panel, which relates to Marcin's question, which is recently bothering me, and it's about data sharing, big data privacy. But my question is the following: as long as we are staying within the scientific domain and the data sets are shared for the scientific research reasons, it's one thing. Yeah, we are wondering about the transferring from the EU to the US, the other way around. So those are, of course, issues. But then we want to go a bit further, meaning that, of course, US, but also in Europe, we want more products in neurotechnology, but in general in medtech. So what I'm recently struggling with is the following case. So a nice study was done, it was published, and the data set can be shared upon request. It's in my case, it's in oncology, not necessarily neuro-oncology, but anyway, I will not even disclose the organ. The data set is there, it's very nice, the study looks interesting, promising, and it could be followed upon. I mean, we could push the TRLs further and go and use this data set, if not to develop a product or a model, then just to externally validate it. But this is potentially commercial use, because this would be done as applied sciences, and this would create an IP values that are sellable. And in order to have a product, you need to have a commercial entity and commercial relation between this product and customers and users. So the problem is probably with the consents. So the patient, as it works right now, the patient needs to provide a consent for the scientific use of the data. This is required by the bioethical committees. And then there's a separate thing. There has to be separate consent for the commercial use of this data. But funny thing I'm observing is that in most studies, the consents are for non-commercial use. But it's not only because all the researchers or the medical researchers and clinicians gathering the data, they necessarily want this. They just didn't know when they were planning this study that the commercial use is even possible and it's worth to pursue it. But after the study is conducted, it's too late, because you have data with only agreements for non-commercial use. So people, especially in Europe, I think, researchers are now learning through experiences and through years of data that were lost to applications. They are very good for science still, but lost for commercial validation. So they are now learning on their mistakes and more people start to put the commercial use also in those data sets, because otherwise the companies need to regather this data, which is costly for the society, for the medtech. Yeah, why in general IT technologies and non-medical fields like finance, yeah, like some financial control and stuff. Why there is the progress of AI is faster? Because it's not even about the regulations. They also have regulations, but it's because of the consciousness of people who are gathering those data and what will happen to them further. So this is in between, like sociology of researchers, law, and the technology. Yeah, what is needed by all parties. But we all want the world to go on, to have more technologies. The concern is that the patient, why is it separate? The patient needs to get something out of it, but eventually they are getting, because there is more products available, so that the quality of health care is higher. But on the way, there is this small little detail that a lot of people overlook, and hence the further progress is slowed down. So this is more like my comment, or if I could ask you to comment on this, because it's struggling in my head, and I'm not a lawyer myself, so I want to know the more regulatory law perspective on this. Thank you.
Maybe very quickly to that. You could also ask for consent instead of getting the new data set, but maybe that's difficult from a scientific point of view.
Especially for oncological patients, as you can imagine.
Yeah, I see the problem.
Fortunately.
No, that is true. The reason is that if you process data and you consent, it has to be transparent in order to be freely given. And transparency needs information about what is going to happen with the data. So that's like the legal idea behind it. That's why we need to really write down the purpose so that the user knows what's going to happen with the data. I mean, another question is if we can regulate it in a different way, so the scientific community can more easily get or use this information. The other side, but that's a different question, we probably won't have time for it now, but whether consent is a concept that makes sense nowadays. Because I think everyone knows that you open a window, browser window, and you just click on, yeah, I accept the cookies, or you click on any tab. It's not really, like the idea is that you actually know what's happening with the data. I think no one really knows what's actually happening with our data. But that's a different topic. But that's just the legal reasoning behind it.
Thank you.
Do we have a question from?
Maybe I try to answer your question. If I understand your case right, you wrote a thesis or certain something based on the data you gathered from patients, and and you have consumed with writing your thesis or this paper this consent, but then you, for the further commercial development of your thesis or the ideas you developed in your book, you are not using the patient's data anymore, but the data in the processed manner. I mean, you are not using the data as such, unless this is not the case. But my solution could be, in your case, could be, I mean, the way of thinking of this kind, that you are not using anymore the pure data.
Yeah, that's a good reasoning, and I was thinking, myself, a lot of people were thinking like this, but in practice, it looks like what's the most important thing is the data. So whatever let's say that I developed a model, I published, but at the end of the day, the model there, it cannot directly be used in commercial applications. So what I would need is anyway maybe a little bit more of data to support this initial data, and then to develop a more specialized model that will also answer the regulatory issues, like the MDR or FDA. They can ask me to run some more analysis, so I need to have access to this data. So it's a good thinking, but in practice it's a bit different. So the currency is the data. not whatever I published in the domain.
So what you like to achieve is the reuse of the original data for most
Yeah,
more
and
sophisticated
most of the
models.
times, if you want to develop a new product, you need the original data anyway.
We all have to think about it.
But there's actually, there are cases when, for example, they had like 300,000 images from echocardiography, and they developed a very nice model that is further reused. And this model is published, so I don't need the data to reuse the model, yeah? So I can create a product that is based on this. But this is a different case, and at least in my case, I'm more interested in developing something, let's say, from the scratch using this data, or validating my new model on this data, which is impossible due to the consents.
Yes, definitely that's more challenging because we have purpose limitation, right? And there is a issue with the initial purpose of the collection and then the reuse. Well, I can't say too much about it, but like there are many discussions when it comes to a level of consent. So like it's to what extent informed consent is sufficient, to what extent we need explicit consent, and how to phrase the specified purpose, because that's the main challenge. So like you need this specified purpose, but at the same time you want to have like possibility to also extend to other uses. So there are discussions about it, and it's difficult to regulate, definitely.
Thank you. So we have to wrap up because lunch is waiting for us. So I kindly give the floor to Professor Klawkowska-Waśniowska to close the conference.
Thank you very much. I think we start with congratulating this panel for their insightful debate. Especially that there are some that need to catch the plane, so this is all excused. And I would like now to just shortly wrap it up. We had 2 days of intensive debate on the past, present, and future. We addressed the law and technology, but our focus had to be narrowed, so we focused on information and data. We focused on services, devices, systems, tech applications, practices targeting citizens, targeting consumers, targeting business. So we have discussed a lot, and today's panel provided also a more global context to our discussion on the EU single market that does not exist in isolation. So it proves that we are open to any discussion, and I hope, though I have to close the conference, I do hope that the discussions will continue. Thank you all very much, and thank you very much to my team, Miłosz and Igor, and to Łukasz and Wojciech for organizing today's debates. Thank you very much.